Hi everyone. Today we have Louis back, and we're gonna continue our conversation about various part of SEC enforcement. Specifically, we're gonna go down the memory lane and talk about ICOs, the past, the present, and hopefully some sort of future. Louis, for folks who have not been with us before, why don't you introduce yourself?
Thank you so much, Olga, and thanks for having me back. Yeah, my name is Louis Cohen. I'm the co-founder of DLx Law, which is a boutique law firm with offices in New York, Wilmington, Delaware, and Washington, D.C., focusing on clients working in the blockchain and digital asset space.
Louis, it's really good to have you back. Your expertise in securities and specifically adventures with SEC are very fascinating. I don't know how you probably find them a little stressful, but I find them fascinating and exciting, and I learn a lot from you. So thank you for joining us. As you know, we're going to have a series of conversations today. It's focused on ICOs. So why don't you tell us what it is? What is an ICO? And then we'll talk about how it evolved over time.
Sure. So, just starting at the top, an ICO stands for initial coin offering, or sale of digital assets that are, sometimes referred to as coins kind of colloquially. And of course, the phrase or the initials ICO sound a lot like IPO, or initial public offering, which is the way stocks are commonly distributed. So they're kind of kissing cousins, if you will, ICOs and IPOs.
Well, let's talk about those kissing cousins. Tell what is the same and what is the different?
Sure. So, the idea that when you think about starting up any sort of new business, one of the biggest challenges is accumulating capital for that business. At the early stages of a business, it's the riskiest. And so, you and, I'm sure your many viewers are very, very familiar with the traditional venture capital path that most companies take. They do a very modest seed round. If they're reasonably successful, they move on to an A round and down the line, and either they're acquired or ultimately do a public offering. When digital assets came along, a light bulb went off that, wait a minute, for a lot of people thinking, is this a new way to raise capital to start a venture without having to go through all that messy, technical legal stuff? Who needs that, right? We'll just sell our tokens and just be done with it. And so the similarity is both with IPOs and ICOs was capital raising to create something that would be value additive. The difference, of course, is that the IPO path is highly regulated. The ICO path, especially in the earliest of days, was the absolute kind of Wild West.
Yeah, I very much remember that Wild West. I was with a few projects at the time and later joined a project that had an ICO. So very much aware about discussing the sort of the overlap between the two. So tell us kind of how it all started. Clearly there's this idea of the capital raise, and as somebody who capital raised many times for either for my company or other people's company, I can't tell you that this is a process I totally recommend for recreation. It's sort of, not very streamlined, and then it takes time, and, you go around the world pitching a business and everyone tells you what's wrong with it. So it's not exactly for, to confidence building. So I can definitely understand why the inclination of entrepreneur is to maybe find an alternative. So what happened, when folks started experimenting with that alternative funding that, and I remember all the conversation around that at the time, how much more democratic and it will be, and how much more access and innovation we will have as a result of that. What happened?
Sure. So, fundraising and sort of decentralized protocols have this sort of interesting relationship, because unequivocally, a large part of what ICOs were about was indeed fundraising to build something. If you're going to code and develop a complex platform, you need developers, you need a range of things that require, money to pay people, to get people to do stuff. So if you want a decentralized protocol, somehow or another you have to raise money. And the idea, at least in the early stages of ICOs, was first people looked at the way the very first digital asset was created, Bitcoin. In that case, there was, of course, no ICO. There was, Satoshi mined one transaction, got whatever, I think it was 50 Bitcoin at the time, mined another transaction, and just kept going, slowly, step by step. And a number of what are loosely called the altcoins, Litecoin and others, kind of followed in that step that just started, with one asset. And then somewhere along the way, the light bulb went off that you didn't really have to do that. You could start by, pre-mining, and this is the term that folks use, pre-mining as many tokens as you want, because at the end of the day, tokens are kind of just numbers. And since there's a unlimited number of numbers, there's an unlimited number of tokens. And Mastercoin, I think, is generally credited as having done the very first ICO. So the idea that in the first block of the blockchain, rather than just starting with one of the digital assets and then 2 and 4 and 8 and whatever it may be, you could just start with, say, 1 billion. And there you have them. Now, the challenge is, how do you get people to fund you with that? But that's kind of just at the beginning how the whole process got started. This light bulb that you could create a bunch of tokens and then ideally fund the development of the protocol with the proceeds of the sale of those tokens.
So if we look sort of under the hood, and I understand the inspiration, I understand the first block. How does it work? How do you connect sort of the economics, the governance, the decentralized portion of it to actual event, and how does it all work out at the end?
Well, that's the key question, Olga. Really. So with the earliest of ICOs, these were really kind of word of mouth largely. Oh, here are some developers. They're really smart. What they're working on is really interesting. They need to be funded. They're going to create, some, finite number of these digital assets, these tokens, these coins, and, buy them now for some, what might appear to be a low price, a penny each or 5 cents each or 10 cents each. And let's see what happens if people start using the protocol and the tokens are in demand. The price should go up. If there's a fixed supply of something and a demand goes up, the price should go up. But in the earliest of early days, these are really largely word of mouth kind of, oh, interesting project, let's get involved, let's see what happens, what the heck kind of thing. That pretty quickly morphed, though, as the prices of digital assets started going up and up and up, and that included Bitcoin itself, as well as some of these newer digital assets like Ether, the native token of Ethereum. As those prices started moving up, people started saying, whoa, this looks good. You mean to say I can buy a digital asset at its ICO for 10 cents each, and then maybe in 6 months or 12 months, instead of being worth 10 cents, they're worth $1 or maybe even $10 or maybe even $100. Wow, that's a lot of money there. I want to get involved. And so very quickly—
That sounds like a gold rush.
Absolutely. And a whole industry sort of started, sprouting up around this to facilitate. So we went from kind of word of mouth very, very quickly to a whole industry around ICOs.
Say I'm an entrepreneur and I would like to do an ICO. It started as a word of mouth, but then it quickly professionalized with all the folks who are selling shovels to the gold diggers.
Exactly. Professionalized is a generous term, I would say. That's I think we all know what you mean.
Yeah, well, I'm trying to come with an open mind from a non-judgmental place to a new technology that professionalizes that professionalizes over time. But yeah, it's a wild, wild west. So you'll find all kinds of folks there. Some of them are more sophisticated than others, and some of them have better intentions than others. And that's kind of the adventure. But say I'm an entrepreneur. I have a talented team of 5, 10 PhDs. They are a very geeky, amazing crew. We can build something revolutionary. What steps do I have to go through to get there?
Sure. So once we moved from the kind of word of mouth stage, the more, as you say, professionalized or at least quasi-professionalized stage, there were a number of steps that it kind of became very quickly. And I was watching this, kind of firsthand. It went from, oh, we could do this to that's the way it's done. So, the idea, for example, of having a countdown clock on a website and, various tools that were designed to create, what my son likes to call the hurry up by now kind of mentality,
FOMO, the FOMO, right?
Right. And so there was a whole process as people iterated and what worked best. And very quickly and dishearteningly, I would say, the focus shifted from the value of the project. And as you said, oh, there's 10 geeky PhDs with really creative ideas. It went from that to what will sell, right? What will generate that FOMO, as you said, Olga. So what people did was they'd create a website and they would just simply start talking up the project. They'd create a logo. Very often, it appeared that much more time was spent designing a catchy, eye-catching logo than the actual underlying protocol. In fact, very often when ICOs occurred, little or no code had even been written. And the idea is, well, look, we'll raise the money. And people were raising huge amounts of money. Initially, it might have been $10 or $20 million, and very quickly became, hundreds of millions of dollars, and in a few cases crossed over $1 billion, which is, just looking back in hindsight, a little mind-boggling. And so the focus really shifted from the project to the marketing and the generating that interest. And then, and I'll pause for a moment, but then, people realized after the marketing, it had to move on to another stage. And I'll get to that in a moment.
Let's definitely talk about the other stage and what could possibly go wrong when we go from, hey, let's build to let's just get away with as much money as possible and market the heck out of it, and then hope for the best.
Exactly.
That is not usually a good idea. That is usually where regulators become very active, and it's already sort of been on the shaky grounds. So before we move forward to the other stage, I use the term FOMO. There's another term FOD. There are a few other terms. Why don't you enlighten us what all that means, so like all of us are on the same page and to make sure that we all follow the conversation?
Absolutely. So FOMO, or of course, the fear of missing out, is one of the key drivers that got people involved. FUD, on the other hand, fear, uncertainty, and doubt, FUD, was kind of the opposite. And in more common parlance, greed and fear, right? In more basic terms. And I think, quite appropriately, what caught the SEC's eye, in addition to the outright flaunting of, securities laws, was the fact that real people, the person in the street, were getting involved. I was exposed to this pretty early on. I was at a private dinner in one of those kind of dining rooms off the side of a restaurant, and you'd have maybe 10 or 12 people. And we were talking about matters relating to blockchain and digital assets. And the server that we had overheard what we were saying and got all excited and said, are you guys working? Is there a new digital asset? Because, I got my mom to buy some of this, and my cousin and my girlfriend bought that. And let me know it was like a hot stock tip, and I
hot stock tip. Oh my God.
Yeah.
That sounds like an amazing conversation. I don't know what kind of parties you go to.
Yeah. Well, I would say, look, if lawyers like me were there, it wasn't that much fun, I promise you, Olga. But I think that's the direct connection there. As the SEC started to realize that this solicitation had gone beyond just a small community of word of mouth technologists and out into kind of the wider market, where taxi drivers and, just regular folks were saying, gee, how do I make a lot of money? That's really where the concern occurred. And
that's successful marketing right there.
Well, maybe too much success. Be careful what you wish for, because it absolutely attracted, appropriate scrutiny, and not only from federal securities regulators, but state securities regulators. So on both sides, regulators quickly got involved and starting asking questions, and threads started getting pulled on. And what people realized was that because so many of these projects, not all of them by any means, but so many of them were nothing more than marketing efforts to get people to buy basically a number. Concern was raised. An analogy, and I know, Olga, you often like my analogies, but
I love your analogies. Go for it.
Analogy I like to use, and you may remember this because it was big for a while. Is there was a company that was selling stars. So stars just generally,
I remember that.
your husband or your wife for Valentine's Day. Oh, honey, I got you a star. It's that one, and it was quite precise because they have unique alphanumeric numbers associated with them, and in many ways the digital asset craze was like that, where all that was being sold at the end of the day was just a number. You got an address and you had some numbers associated with it. And there was nothing underlying these. And this is what, caused a lot of people concern. The fact that people were raising huge sums of money and not parting with anything, of meaningful value.
Yeah. The art and science of marketing is very important. It is also very important that it is attached to substance. When it becomes primarily motivated by money, and the substance and marketing are two separate things, a lot of things could possibly go wrong. We're getting to the juicy part, which
yes.
We're going to be talking about the SEC. So we now have the taxi drivers and all kinds of people who have heard, the quick, get rich schemes. I certainly had many conversations with multiple taxi drivers, and once they found out that I was in that industry, and find out how they can get in and kind of get access to that opportunity. And as that marketing campaign becomes successful, obviously it attracts attention of SEC. What happened? When did SEC get involved, and what was the reaction?
Sure. So I'm going to have to run through this quickly because it is a very, very long and detailed story. And, there's a lot in writing about this, both from myself and, many other lawyers who are active in the space. So I'm going to just try and kind of run through quickly. And many people watching may be aware of the broad parameters. The SEC's first shot across the bow related to a rather unusual project called the DAO. Of course, a DAO, as many of your viewers may know, is a decentralized autonomous organization. And the idea is that people kind of group together for some sort of economic activity where computer code really drives the relationship. There's no formal binding among them, at least in the basic case of a DAO. And the DAO, which is a particular DAO, was created by a group in Germany who had a project called Slockit, which was a sort of indirectly lock for a door. Their slogan, which I love, was "Don't just lock it, slock it," which kind of tells you something here. So the DAO was created basically as a decentralized investment fund. The idea was people would contribute Ether, it would be held in a smart contract, and then people could vote on projects that would be awarded some of that Ether to build, and then get sort of tokens or other digital assets in return and make money for everyone. It blew up, as many people know. It's its own. You could spend an hour talking about what happened and what went wrong with the DAO, but it blew up in the summer of 2016, shortly after it launched, and that's its own separate story. What's important is the next summer in 2017, the SEC came out, unless I have my years wrong, it was 2018, but I think it was 2017. Forgive me if
Let's just say the next thing that happened.
Yes, exactly.
In the grand scheme of thing of how old the universe is, 2016 or 2018 is just a margin.
Exactly. I want to say, the SEC was proposed in 2017. And maybe one of your viewers will correct me. In any event, so the SEC looked at that arrangement and published a report, which was not an enforcement action. It was just sort of a statement to the world. We've taken a look at this. We believe that these digital assets are securities and these sales should have been registered, and they were not. And we're just letting the world know. And I think, the SEC and their enforcement staff probably hoped that a clear and strong message like that would kind of cut things off. It did not. If anything, it caused people to sort of dive in harder because they looked at the DAO and they said, well, they were doing something very different. They were creating this sort of decentralized investment fund. Of course, those are securities. Everybody knows that. What we're doing is different. And people justified in different ways what they were doing as being different. And so the Dow report itself did not have quite the impact that people were hoping for. In December of that year, the SEC, and prior to that, between the Dow and December, there were a couple of enforcement actions against outright fraud schemes, which again really didn't slow anyone down because they're saying, well, look, those were fraudsters, and they were just bilking people, and I'm not a fraudster, so I have nothing to worry about. What really changed the temperature, Olga, is that in December of 2017, the SEC created enforcement action against a smartphone app called Munchie. And what Munchie wanted to do was create an ecosystem around dining and sell tokens that would in some way promote this ecosystem. And Munchie was stopped in its tracks, never sold its tokens. And the SEC's reasoning there was really the foundation of everything that's kind of gone on since.
So I remember Munchie. I very vividly remember Munchie because yes. I had a popcorn and I was following every step of the way when it comes to Munchie. For many reasons. It's because, actually precisely because what you just explained is they had seemingly good use.
Yes.
It was clearly not a pyramid scheme. It was clearly not just a marketing exercise. We can judge the merits of the product, but the intent was to make the world a better place, so to speak. So they had a use case. Whether it would actually work in the end, that's a different story. And they're, somewhat legitimate company. And help me understand how SEC thought through that and how we moved from thinking that this doesn't apply because I'm, fraudster to, hey, I'm actually doing a regulated activity. Even if I have a legitimate use, I still need to follow laws.
That's a great question, and Munchie really did mark a turning point, as you say. The takeaway from Munchie, and this is really critical, there was no suggestion of fraud or bad behavior. Really, it was just a fundamental violation that, as far as the SEC was concerned, in the process of selling the tokens, they were conducting a securities offering. They had not registered with the SEC. It was available to retail. Bang, strict liability. You violated Section 5 of the Securities Act of 1933. You can't do that. So, but the takeaway, and this is really the important point to me, Olga, is that basically what Munchie was doing is something similar to what a lot of other projects were doing at that point in time, which was selling what is sort of loosely known as a pre-functional token. And this kind of gave rise to a term, which I'm sure you heard many times in that period, of the idea of utility token, and the idea that really what Munchie did wrong was they sold their token at a point when there was not, the network had not been fully created or developed, and that if you just sold your token at the time the network was developed, everything would be okay. And that was kind of what a lot of people took away from the Munchie action.
Let's talk about the utility, because I've been in numerous conversations with all kinds of people, including the very scary people, about what it means to have utility, at which, it very quickly becomes, essentially a philosophical debate, what it means for, I'm not always clear what it means for me as a human to be useful. And for the, token that is, not even cannot be touched, that becomes, very abstract conversation very quickly. Help me understand why, people zeroed in on this utility requirement, and kind of how the meaning of that has transformed over time.
Absolutely. That's a key question. And for this, we'll harken back to my prior episode with you, and hopefully folks got to see that. If you didn't, go back to Olga's website and click on that and watch that, because we talked about this in detail. But I'm just going to do a quick recap. Long before digital assets, there were investment schemes that involved the sale of some object or another. Sometimes it was real estate. Sometimes it was, something consumptive like whiskey. Sometimes it was animals that were being grown for furs. There were many.
We talked about chinchillas.
We did.
Go back to chinchilla conversation. I love it.
Exactly. And this ties into this point on utility very closely. All of the things sold pursuant to all of these schemes that long predated digital assets had some inherent utility. The catch was, and the SEC and courts, more importantly, courts were always very clear about one thing, was the person who was doing the buying, were they really interested in the consumptive use of whatever was being sold. That is, if it was a chinchilla, was it going to be a pet? If it was an earthworm, were you going fishing? If it was real estate, were you going to live there? Was there a consumptive interest in purchasing, or was there something else? And if the something else was, actually, I have no interest in this thing whatsoever, what I want to do is wait a while and then sell it at a higher price. And if that's the case, that's what the SEC and courts would call an investment intent. And this is really the key thing, where utility sent people in, unfortunately, a very, very mistaken direction. People focused on, well, okay, my network is working, there is utility. The problem was, and the SEC focused like a laser on this, is the purchases were not being made for the consumptive use of that digital asset. People were buying these digital assets in huge quantities and had clearly no evident interest in actually using the protocol for anything. What they were interested in doing is getting the digital asset cheaply and selling it later at a higher price. And so the utility or lack thereof of the network or the token is really a red herring. The question, really hearkening back to our discussion about the Howey case, is there a purchase of something, whatever that may be? Is the purchase being made with investment intent, that is, to make a profit? And if there is a profit, how is that profit going to be created?
Yeah, that gives me a lot of deja vu and maybe to some extent a little bit of PTSD. What happened after Munchie? So Munchie had people spinning about all kinds of things, including what utility means and at what point you provide utility to the world and the consumptive use. What happened next? What happened with where is SEC? A few steps later and maybe even today.
So what happened next was, some people didn't really learn the lesson, and there were a lot more enforcement actions, some by the states, some by the SEC. But there was an important development. That development was from a West Coast law firm that thought they had, a better way of launching new protocols. And they called that the Simple Agreement for Future Tokens, or SAFTs. And if we didn't give you PTSD before, when I say SAFT, it probably does. So the SAFT...
The whole alphabet soup is coming, folks. The whole alphabet. Let's talk about SAFT. I would love to.
Yeah, so the SAFT was a great idea, at least at a high level in theory. The idea was it was sort of a riff a bit on the Y Combinator SAFE, which everybody in your community, I'm sure, well understands, the Simple Agreement for Future Equity. In the case of the SAFT, the idea was, okay, let's sell a security. Let's lean into the SEC's approach. When we're fundraising, we're going to sell a security. And then later, once our network is operational, we will give you a token which has function and utility. And so that became almost overnight the far and away the most popular way of raising money. So rather than selling just tokens directly, people would invest in a SAFT, which was treated as a security. The appropriate steps were taken for private placement. So the Form D, which is the appropriate form as a notice filing with the SEC, was made, and people followed all the steps. And they thought, okay, we've done everything correctly, or at least as far as we can tell. When our network is live and up and running and the token is available, then whoever funded us initially, that small group of people, can now sell their tokens free and clear of any securities law issues. And, Bob's your uncle, it's all good. That process was stopped by probably the best known case, which I'll talk about in a sec, which was Telegram. But I'll pause there for...
Yeah, let's talk about Telegram. Telegram, I was very much in the industry at the time, and I remember that. Let's talk about Telegram. Telegram is definitely should not be a suspense for too long. We should get to the point.
Yeah. So that's really, and this is really for people who are like, get on with the story and finish up. We're getting to the end of the story. So Telegram is probably the single largest, I believe it was, to the best of my knowledge, the single largest fundraising for a new blockchain-based protocol. And it's an amazing idea. The Telegram team, to the best of my knowledge, are widely respected. The Telegram product, I think probably all of us have that, on our phone. It's an amazing messaging app. The idea of connecting e-commerce through a native digital token for the Telegram app was a brilliant idea. And I think it attracted a tremendous amount of interest. I believe from the SEC filings that ultimately followed, it was something like well over $1 billion, maybe 1.5 billion. Huge amount of funding. because everybody was really excited about this. And again, the team involved really sought to do everything the right way. Unfortunately, when it came time, after I think well over a year after the initial SAFs or SAF-like instruments were sold, they don't always use the term SAF, but basically, funding agreements. The SEC came up and filed an injunction against Telegram. Now, there's a lot of unknowns in what happened, what dialogue occurred between the SEC and the Telegram team leading up to the injunctions. And I'd love to personally have a sense, but that injunction stopped them in their tracks.
Yeah, it was very clear that there was a lot going on behind the scenes. It sounded like the Telegram team was cooperating.
Yes.
at least to some. I mean, who doesn't cooperate with SEC? it's one of those invitations that's hard to decline, right?
Yes.
So what obviously we don't have all the details, but what do you think kind of happened, and how do you think Telegram went on with its life without, getting to the end of it?
Yeah. So, I mean, by all intents and purposes, things were going well as far as I can tell. They were, they hired a lot of developers. They were coming up with some intriguing ideas, and a lot of things were happening. The injunction stopped that, as you observed, and it moved quickly into really full-fledged litigation in the Southern District of New York and District Court in the state of New York. And there was some motions filed back and forth, and ultimately, a hearing was held. And I was fortunate enough to be able to attend. It was sort of pre-COVID period, and we actually had a group of people in the courtroom all together. And the judge,
you guys had a picnic and a party and watching show. All right.
Yeah. So the judge listened to arguments, very well presented from both sides, and went away. And a couple months later, came out with a decision in favor of the SEC. And the judge is a very well respected district court judge who had a lot of experience, and he really kind of went through the arguments and came up with what, at least in my view, was an insightful position, which is, yes, you did everything right, Telegram. That's not the issue. The issue is that those initial sales of the digital asset, the people who acquired them never really intended to hold them or use them, and that it was really necessary as part of this overall scheme that these initial purchasers would be distributing them to the wider public. And if Telegram, you couldn't sell your digital asset to the wider public directly without complying with various disclosure rules and whatnot, then finding a group of people to fund you while you're waiting for your network to become developed, and then waiting for them to sell the tokens to the public, that doesn't really help you. You still, you have an indirect sale to the public, but it's still a sale to the public. And that was the position that Judge Castell took in the case. And that really has, I think, really kind of become the current view of where we stand today on token sales.
Yeah, and I highly recommend reading that decision. Very enlightening. It is very well reasoned and well written, and very useful if you're practicing in the industry today. We're coming to the end. Let's summarize for all the listeners kind of where we are in this ICO today in terms of laws. I know there have been a few iterations on SAF and other things. I was out kind of going through archaeological excavation of the human mind and legal mind creativity. Let's kind of talk about where we are today, and then kind of what happened after kind of when what's known as crypto winter, and where we're going in the future.
Absolutely. So we'll wrap up, just as you say, kind of summarizing things. So what followed, these events, and a lot of things all came together, but they kind of manifested themselves in a huge decline in virtually all digital asset prices, which, again, in the winter of 2019 into 20, became known as crypto, or 18 into 19. Gosh, kind of all my years mixed up. In any event, became known.
18 to 19, roughly speaking. Yes, I remember that vividly too.
Yes, but more vivid identity than me, I will say, but I think I blocked it out of my mind. But really, when we summarize this, what we're looking at is that we are at an absolute inflection point in terms of the development of new technologies. In some ways, to my mind, somewhat reminiscent of the move from horse-drawn traffic to the railways, much more like the railways than like the automobile, because the railways were networks. And, most people look back at the era of railway development, seeing the finished product and saying, well, that all makes sense. But in the moment, the railway development suffered many of the same kinds of issues, misrepresentations and schemes and plots and all kinds of things. But at the end of the day, when you kind of cut through everything, what people saw, in the post-Civil War period in the United States, with this incredible opportunity to build out these networks, even if they weren't quite sure what the rail networks were going to do or how they would be used. And what we're seeing, in my mind, is something very similar with digital assets, that people are incredibly compelled to the idea of digital asset networks that are, either completely decentralized or largely decentralized, and that, some of these networks will become intensely valuable in the same way that for, the better part of 100 years, the rail networks became intensely valuable. And people want to participate. And, water kind of finds its level. People want to put capital into this space. What, in my mind, if I had to kind of summarize, we need to work with our regulators who are doing an amazing job at the SEC, at the state level. And we have to work with legislators to come up with ways to allow capital to flow into the space here in the United States without, gross violations of disclosure and all the problems that have occurred. And I think we're still trying to kind of feel our way toward that point. How do we nurture and develop decentralized networks without, passing through this whole securities law violation? And I'll just plug the SEC Commissioner Hester Peirce. Many people will know has made a proposal known as the Token Safe Harbor, which seeks to give projects a 3-year grace period to kind of find their legs. And it's a brilliant proposal. And she actually put the second version up on GitHub for commenting and forking. And it's a brilliant, brilliant idea. But whether that's the solution, whether it's something else, what we have right now does not work. And we have capital that wants to come into the space. And so we do need, as a society of lawyers, regulators, policymakers, and others, figure something out to make it work better than it does today.
Yeah, and you can tell that SEC is trying. I mean, how many times have historically SEC put anything in GitHub? Right. I know the answer to that question. They're clearly trying to meet the community where they are, right? Yes. Most developers are in GitHub. They're not on LinkedIn. They're not in other places. They're usually on GitHub, and so you can definitely see that everyone is trying, and there is value, and there is an absolute great opportunity. Yet we really have to protect the public, the folks who put in their money, and the incentive when you have a lot of money to defraud. And there is sort of an opportunity to build it in a safer way. For those folks who are thinking, gosh, where does this field live? I think it's still in the very absolute beginning. More is coming. Louis, let me know if you disagree.
Absolutely agree. 100%.
So the time to learn and get in is now. Louis, thank you so much. Thank you for going through kind of ICOs and their kind of how they're unfolding, and the value and the opportunity for folks to learn and be part of building. I always enjoy you here on the show, and I learn a lot from you. So thank you so much for joining.
Well, thank you, Olga, for hosting. You're an amazing host and have a great show. So thank you, and I'm sure we'll be talking again before too long.
Oh, we'll be talking. We have another episode coming with you. Thank you, everyone, for joining, and let's build together. Bye, everyone.